specialising in employment law, and I've been doing that job now for a bit over 7 years. As Liz has said, this is the third in a series of webinars covering issues regarding unfair dismissal claims. I started with a general overview of the law on unfair dismissal, and last month we covered dismissals on the grounds of misconduct. If you missed those, please do log in and have a listen at your leisure. Today I'm here to talk to you about the key legal and practical issues that arise in cases where employers are concerned about the capability of employees. Capability dismissals tend to fall into one of two camps. Dismissals because of competence of employees, or rather the lack of it, and dismissals on the grounds of ill health. We're going to look at both of those in turn, and as Liz has said, there should be time for questions at the end of the webinar. But if you have anything that you wish to discuss in detail, you'll find my contact details at the end of these slides, so do get in touch. The current provisions regarding unfair dismissals are contained in the Employment Rights Act 1996, which provides that the dismissal of a qualifying employee will be unfair unless, first, the employer can show that the reason or the principal reason for the dismissal was a potentially fair reason, and capability is one of the potentially fair reasons. Secondly, the tribunal finds that in all the circumstances, including the employer's size and administrative resources, that the employer acted reasonably in treating that reason as a sufficient reason for dismissal. That means that the dismissal must be both procedurally and substantively fair. The statutory definition of capability as a reason for dismissal is set out under section 98(3)A of the ERA, and it encompasses competence, health and qualifications. Section 98(2)A, as I've set out, provides that a reason falls within this subsection if it relates to the capability or qualifications of the employee for performing work of the kind which he was employed by the employer to do. And section 98(3), which I've paraphrased on the slide there, puts a bit of a gloss on that. Capability means capability assessed by reference to skill, aptitude, health, or any other physical or mental quality. And qualifications means any degree, diploma, or other academic, technical, or professional qualification relevant to the position which he held. Looking at fair procedure in these kind of situations, provided one or more of the potentially fair reasons for dismissal applies, whether a dismissal is fair will depend on the reasonableness of the employer's decision in the particular circumstances and the procedure followed. In the context of dismissal for capability reasons, the tribunal will not only want to be satisfied that the employer honestly believed on reasonable grounds that the employer, sorry, I'm just getting a bit of rustling there, we're just going to sort that out. Hi everyone, sorry about that, I'm back. So yeah, where was I? In the context of dismissal for capability reasons, the tribunal will not only want to be satisfied that the employer honestly believed on reasonable grounds that the employee was incapable of performing their job, but with regard to the overall reasonableness of that decision, will consider whether management failed to discharge its own responsibilities towards the employee. An important element of this will be the extent to which the employer has clearly communicated the requirements of the role to the employee, or where applicable, has provided necessary support and training. It's a basic principle of fairness that a decision to dismiss or take other disciplinary action should not be taken without a disciplinary hearing or a meeting. And generally, case law has established that a dismissal for poor performance will not be fair unless the following key elements are present. 1, a proper investigation into the problem has taken place. 2, the employee has been made aware of the problem and has been given an opportunity to improve within a realistic timescale. 3, the employee has been provided with appropriate support and possibly training. 4, the employee's progress is reviewed during the review period. And finally, the employee is offered a right of appeal against the decision to dismiss. To help employers and employees deal effectively with issues of alleged misconduct or poor performance, ACAS has produced the ACAS Code of Practice on Disciplinary and Grievance Procedures and some supporting non-statutory guidance. It's not a legal requirement for the ACAS Code to be followed, but employers should have regard to it, as an employment tribunal is obliged to consider the ACAS Code when deciding whether a dismissal is fair, and specifically whether a fair dismissal procedure has been followed. Also, be aware that an unreasonable failure to follow the code by either party may result in compensation being increased or decreased by up to 25%. The content of the ACAS code doesn't really add much to best practice and the existing case law, but it is nevertheless essential reading for anybody involved in investigations and disciplinary hearings, so please make sure you're familiar with it. And I've put a link on the slide there where you can download a copy of the code from the internet. Setting the standard required. Express terms aside, it's implied into every contract of employment that an employee will perform the role to a minimum required standard. What the required standard is will vary from role to role, and it may encompass not only the technical aspects of the job, but more subjective aspects, such as the employee's attitude or ability to interact with clients and colleagues. Some requirements of the job are so obvious that the employee's attention doesn't need to be drawn to them. For example, there were some observations made in a case called Burns and Turboflex Limited, where it was said that a van driver does not need to be warned that he should not drink before he drives, the personnel director of a large company does not need to be told he should not make racist or sexist comments about or to members of his staff, and a pilot does not need to be warned that he should not crash the plane. Aside from very obvious requirements of the job, it is important for the employer to have drawn the employee's attention to the required standard, usually at the outset of employment, and then if it becomes necessary, for the purposes of a capability procedure. If performance targets apply, for example, a tribunal will want to be satisfied that an employee could reasonably be expected to have known about them. Were targets brought to their attention? Were they made aware of the possible consequences of not meeting certain targets? Probation periods are a useful tool for employers. They are frequently used for new recruits and are often set at between 3 and 6 months. That's an ideal time for an employer to assess an employee's suitability for the role. That's because the employer's exposure to claims during this period is limited for two main reasons. First, the contract is likely to be terminable during the probation period on a week's notice. And secondly, the employee won't have acquired the qualifying period necessary for most unfair dismissal claims. An employer may also want to reserve the right to extend the probationary period for a further limited period. If an employee doesn't perform to the required standard during the probationary period, they may be dismissed before the period expires, and there's no requirement that the employee be allowed to complete the full period. Alternatively, at the end of a probationary period, the employer may confirm satisfactory completion of the probation. It is important that employers diarise the period of probation carefully to ensure that the date is noted, the end date is noted, and that a decision as to satisfactory completion or otherwise is reached and communicated to the employee before that date passes. If an employer fails to communicate with the employee at the end of the probationary period, it's likely that the period will lapse. Probationary periods can also be applied for those promoted to a new role. Where applicable, a probationary period needs to be clearly communicated to the employee. Providing this is done, the employee will be aware that they are under review and that they must satisfy the employer of their suitability for the role before the contract is affirmed. By entering into a probationary period, the employer is expected to conduct a reasonable appraisal of the employee's performance and to bring any inadequacies to their attention so that they're given the opportunity to improve. As the next slide says, appraisals are important. To demonstrate a reasonable belief that an employee is incompetent so as to justify dismissal, employers need to produce some evidence of poor performance. Whilst that may be gleaned from data such as sales or productivity reports, records of customer complaints, or a demonstrable fall-off in trade, the most important evidence will often be provided by those managing and supervising the individuals concerned. A performance appraisal system that is diligently pursued by the employer can prove invaluable in motivating staff, but can also provide important evidence of performance problems which can later be used to support a fair dismissal. In the event of dismissal, the employer is also likely to be better placed to demonstrate that opportunity for improvement has been given if regular appraisals have been undertaken. In order to be effective, appraisals should be conducted honestly. Managers who provide unduly positive or flattering feedback which doesn't reflect the employee's true performance may find that this is later used to undermine an employer's argument that belief in incapability was reasonably held. Employers who fail to tackle performance issues through an appraisal system may also find it will hamper their future business decisions in other respects. For example, in redundancy situations, employers wanting to give someone a low score for performance will be hindered if a low score isn't corroborated by past appraisals. Poor performance can take many different forms, but some common examples include lack of productivity or slowness, inflexibility, and failure to establish good working relationships with colleagues or customers. Addressing performance issues as soon as they arise is important from a legal perspective and can also have a number of advantages for both employers and employees. For example, an employee is more likely to turn their performance around if concerns are highlighted at an early stage than if matters are left to fester. If offering training and support results in a positive outcome, then that's less time-consuming and costly than going through a poor performance dismissal procedure and recruiting a replacement. And being able to demonstrate that an employee has been given support and the opportunity to improve will greatly improve the employer's chance of effecting a fair dismissal. What I would say is avoid taking a heavy-handed approach. In seeking to address performance issues, it's unlikely that an employer who follows a reasonable procedure will break trust and confidence in the employment relationship. However, the employer must take care not to criticise or embarrass a poorly performing employee in front of colleagues. There was a case of Hilton International Hotels Limited versus Protopapa. There, the claimant's supervisor reprimanded her severely in front of other employees. Upholding her claim for unfair dismissal, the EAT found, that's the Employment Appeal Tribunal, found that she had been humiliated, intimidated and degraded to such an extent that there was a breach of trust and confidence which went to the root of the contract. And that was the case even though the supervisor would have had no authority to dismiss her. One of the questions which has been put forward ahead of this webinar is whether capability and disciplinary need to be kept separate. And the answer really comes down to how you analyse the situation before you. Is performance really the issue? When investigating the problem, employers sometimes find that there are other issues that need to be addressed instead of or in addition to the poor performance. For example, ill health or disability, problems with childcare or caring responsibilities, poor management within the team, harassment or bullying by a manager, or an excessive workload leading to inability to deliver and stress for the employee. We will come on to ill health dismissals shortly, but where poor performance is caused or exacerbated by a disability, employers will need to comply with the disability provisions of the Equality Act 2010. Once disability is identified, any decisions taken by the employer, such as a warning or a dismissal, will need to be a proportionate means of achieving a legitimate aim. And before reaching any such decision, the employer will need to consider what reasonable adjustments it might make to support the employee. Adjustments might